And we're here on Ms. McCain's motion for contempt, and then there's a corresponding motion to continue the matter submitted by Mr. Ibarra. So first off, let me just touch base with you, Ms. McCain. Did you receive a copy of the motion by Mr. Ibarra to continue the matter?
Yes, I did.
Do you have a position on that motion?
I would not like to continue. Or
Okay.
I want to settle this as soon as possible.
Okay. So you would be in opposition to his motion. You
Correct.
want your motion heard today.
Yes.
Okay. And then Mr. Ibarra, your basis of your motion is that you weren't given the requisite 21 days to respond.
Yes.
Okay. Do you have any response to that, Ms. McCain?
Yes, he hasn't paid his portion of childcare since April 9th.
Hmm.
I've told him.
So response to the motion to continue, just because what he's saying that based on local rule 88, there wasn't from the time of service until.
Okay, I'll try and
just a friendly reminder to everybody that's on the Zoom call, if you'd please ensure that you're muted. Thank you. So what he's saying is that based on the local family rule 88, that from the time of service until the time of the hearing, there needs to be 21 days. And what he's saying is that that has not happened, indicating that let's see, when I looked at it, the timeframes were short. So he's indicating the reason he wants that is he wants to be able to respond to your motion.
Okay.
So I think I'll continue the matter. I think I'll just continue it 1 week. If the party's available next Monday morning.
Yes.
Yep.
Okay. So I was handed a motion for granting the continuance. I'll sign off on that. So we'll just set it over 1 week, and so that will allow Mr. Ibarra to file a response, and then Mr. Ibarra, just make sure you file your response and give a copy to Ms. McCain. And then we'll be back here next week.
File it first and then give me a copy.
Yeah, I mean, you file and just so that way everybody knows what the other party is saying.
And that's Monday.
Yeah, Monday, the 25th at 9 a.m. I've signed off on that order of continuance. Feel free to take a seat, Mr. Steffen. See everybody next week. And then I'll ask if Stacy Hyatt, if you're on the line. Stacy Hyatt.
Yep, I'm here.
Okay, welcome to you, Ms. Hyatt.
Thank you. Good morning.
All right, so this is a motion brought by Ms. Hyatt related to a court order from June 27th, 2019 regarding full-time income information. And it looks like service was proper upon Mr. Steffen, and indication was that Ms. Hyatt never hadn't received that full-time income information until just recently, where looks like Mr. Steffen did file those. So at this point, our motion today is somewhat limited in that it's a motion for contempt as to that specific provision as far as documentation being shared between one party and the other. It's not extending to back child support. And correct me if I'm wrong, Ms. Hyatt, in your motion, you weren't asking for a finding of contempt related to past due child support. Is that correct?
I'm not sure if I worded it correctly, but I was looking for past due of what it should have been. Yeah.
Okay. Well, let me take a look at the motion, because when I looked at the motion initially for the show cause of the contempt, that was my understanding that it was just limited to the documentation, not to the past due. So I'm looking in paragraph 2 of your motion. You're indicating that the order was not obeyed, which was the full-time pay stubs were not provided after 90 days to adjust the child support as ordered. And then it says the judge ordered pay stubs for full-time employment would be provided to the mother after 90 days. Then a money judgment that you are asking the court to approve a judgment ordering the other party to pay back child support of $34,000 from October of 19 to June of 24. So in your declaration in support of that request, that you were ordered, Mr. Stefan was ordered to provide full-time pay stubs to the mother so that the child support of $100 for 2 kids could be adjusted accurately. Asked multiple times, hasn't happened, haven't filed until now because summer camp prices, costs are going up, kids are getting older. And I'm hoping for a back pay at reasonable rate of what child support should have been adjusted to what would be fair. So I kind of see what you're saying there, Ms. Hyatt, is that the contempt, the motion, in my mind, it's the focus is the pay stubs, and that kind of tangentially and not necessarily stated with clarity, nor with any declaration that states on these months I have never received child support in the court ordered $100 per month. There's not that clear statement. So I'm going to limit the motion today to the pay stub issue. And then if on the back child support, if that's something you feel is appropriate, then you could file that specifically with supporting documentation and declarations. So that portion of the motion, the pay stub, is fairly straightforward. Do you have any additional comments or argument you want to share on that?
No, not on that motion.
Okay. And then Mr. Stefan, what's your response to the motion?
I know I didn't do it after 90 days. I should have, but I have helped over the years, like not recently because I just can't financially afford, but I have helped over the years with summer camps and schools in the beginning and driving back and forth to pick them up. And I gave her half the house in the divorce and all that.
Okay.
So.
All right. So it's a pretty straightforward motion as far as the pay stubs. There was an order for that to happen. It didn't happen. So I'll make a finding of contempt, and I'll impose a $100 civil sanction. And that contempt, I think at this point, has been purged by virtue of Mr. Steffen's supplying the pay stubs. And just making sure, Ms. Hyatt, you received copies of those pay stubs?
I received them through the Division of Child Support copy when they sent me for that to be adjusted. So
okay, all right.
I never personally received them from him, no.
Right. Okay. All right. So I guess at this point that it wasn't directly from him, but eventually those records came to your possession. All right. So I have a proposed order here related to the contempt. So I'm indicating that there's the $100 civil sanction that's imposed by indicating that the court order of June 27, 2019 was not obeyed. That I did indicate that Mr. Stefan is able to follow the orders and is willing to follow the orders, in that he's provided the pay stubs that were ordered. The other sections on your proposed order, Ms. Hyatt, on sections 4, that related to parenting plan and residential time. So I just whited out those portions because that's not applicable because it was a child support order. And then the money judgment portion, that's where you indicated the past due supports, you had pre-filled that out. So I whited that out, but then I added the civil penalty of the $100 showing you as the creditor and Mr. Stefan as the debtor. And then I didn't make any other adjustments other than I signed off on that contempt order. So that'll conclude today's hearing. Mr. Stefan, do you have any questions? Ms. Hyatt?
No, thanks.
Okay, that'll conclude things for today. Thank you.
Thank you.
08
is the cause number. I see Ms. Russell is present representing the state. And Ms. Russell, can you hear me okay?
I can, Your Honor.
Okay, very good. And I'll ask if Cameron Clark, are you on the line, Cameron Clark?
Yeah, I'm here.
Okay, welcome to you, Mr. Clark. I'll ask if Holly Clark is present.
She messaged me earlier saying she wasn't going to be present.
Okay, thanks, Mr. Clark. I'll just call out for sake of completeness. Holly Clark, if you're on the line, please unmute and state your name. Holly Clark. Okay, thanks. All right, let me just grab the proposed orders here. And Ms. Russell, did you receive Oh, pardon me. Mr. Clark, did you receive proposed orders from Ms. Clark related to child support?
I did not receive any from her. I received some from the state, or from DSHS, I believe, and those are the ones I initially submitted. And then I went and served the serving to that office that was over in Longview. And then that was as far as I was aware. That was all I needed to do, but I didn't go any further than that.
Okay, so the state's proposed child support order sets child support that Ms. Clark would pay you at the amount of $291. Did you receive that document?
Yes, Your Honor.
Okay, do you have any opposition to that?
I don't need the child support, and like I was agreed with her that we don't need the child support, but if like she's required to pay it, but I don't have to accept it, then we're okay with that. But I don't need any child support if we don't have to.
Thank you. Ms. Russell?
Your Honor, there is a history of TANF in this case, but it was received by Ms. Clark. I don't believe that the state has a strong interest in the amount of child support, only that child support, an order is entered that has the appropriate medical language. I would also like to confirm that for the final, the state didn't receive a copy of the final proposed. If there haven't been any changes from the initial proposed, then the order is appropriate. But if there's been any changes, then I would need to see those changes.
Meaning changes to the child support order?
To the proposed parenting plan. I'm sorry, there was a proposed in February, and they're proposing a final, I assume now, but I'm not sure if there's been any changes.
Okay. All right. So I have a proposed parenting plan here. Mr. Clark, did you supply a copy of that to Ms. Russell or the state?
I think the only parenting plan that I submitted was to the courthouse, the proposed one, and then the final one. I didn't submit anything else to the state besides the initial paper that I was told to serve from the meeting with the I don't remember what it's called, but the person right before this meeting.
Oh, the courthouse facilitator?
Yes.
Okay.
Your Honor, if Mr. Clark remains the custodian on the proposed final orders, and I don't have any objection to not receiving them. That's really the only piece of information I need from them at this point.
He is nominated and listed as the custodial parent in paragraph 7 of that proposed parenting plan.
In that case, then I would just ask that whatever child support is entered contains the proposed medical language, and any amount that is worked out between the parties in the court is acceptable
Okay. Thank you.
to the state.
Okay. All right. Thank you. And Mr. Clark, you indicated that you're not seeking child support, and Ms. Russell's indicated that the state's interest is related to the medical language, which is included under, I think, paragraph 20. Is that correct, Ms. Russell?
Yes, Your Honor. It's 20 and 21, I believe. It's 2
20 and
paragraphs.
21. Okay. All right. So, and then, so the state's position is that if the court zeroed out the child support amount but kept the other amount, the language related to medical, that then the state would be fine with that?
Are you talking to me, Your Honor?
No, I said asking Ms. Russell. Okay, so Ms. Russell, her camera turned off and she's unmuted, but she's not responding. So double checking let me swing back then to Mr. Clark. Mr. Clark, with regard to you, if the child support order ordered $0 of a transfer payment, but included what the state wanted as far as medical language, do you have any comment on that?
I'm not 100% sure what you're referencing when you say the medical language. But if you're talking about like the medical insurance and like dental insurance and everything, I do have really good medical and dental and everything else underneath my work, and she's going to be fall under that. Like I won't need any state assistance for anything.
Okay, I'll just read it to you so you know what it says. It says paragraph 20, medical support. It says public health coverage. Holly Clark has enrolled the child in public health care coverage and does not have available at no cost accessible health insurance, and does not have available at no cost accessible health insurance coverage through an employer or union. If accessible health insurance coverage becomes available at no cost through an employer or union, this parent, meaning Holly Clark, must enroll the child. All parents must enroll the child in accessible health insurance coverage through their employer or union up to 25% of their basic support obligation. So it sounds like you've done that, Mr. Clark. Then it goes on to say all parents must pay his or her proportional share of the premium for public health care coverage for the child. Public health care premiums are not included on the child support worksheets. Separate payment is needed. A parent or non-parent custodian may ask the Division of Child Support or the court to enforce a payment for proportional share. Paragraph 21 says healthcare coverage if circumstances change or court has not ordered. If the party's circumstances change or if the court is not ordering how healthcare coverage must be provided for the children in Section 20, a parent or DCS, Division of Child Support, can enforce medical support requirement if a parent does not provide proof of accessible healthcare coverage, which is coverage that can be used for the children's primary care. That parent must get or keep insurance through his or her work or union, pay his or her share of the parent's monthly premium, and pay his or her share of the monthly medical cost or cost of any public health care coverage, such as Apple Health or Medicaid. So it sounds like you're doing what you're supposed to do under that language, that you're covering your child on medical health insurance through your employer. Ms. Russell, is that your take? Is that he would be?
It's my take that he's compliant, Your Honor. I would still like to see that section of the order entered, as well as the next section, which includes the proportional share language for medical and for daycare. And a worksheet is required to support an order, but whether or not the court makes changes to that worksheet is, of course, up to the court.
Thanks. Mr. Clark, the other section is paragraph 22. It says uninsured medical expenses. It says each parent is responsible for a share of uninsured medical expenses as ordered below, and it says proportional share. And proportional share is based on the state's indication that Ms. Clark has income at $2,035 a month, and you have net income at $3,079 per month. So whatever the percentage of those uninsured medical expenses would be proportionally shared between the two of you. So I don't know if it's like a 60-40 split, but something in that realm. I didn't do the calculation. So do you have any questions about that, the proportional share, Mr. Clark?
No, Your Honor.
Okay. We'll keep that in there. We'll keep the 21 through 22 in there. And since Mr. Clark is not asking for a set dollar amount of child support, I'm just wondering if a nominal amount should be applied there. Ms. Russell, do you have any input on that?
The state doesn't have a position on that, Your Honor.
Okay. And Mr. Clark, your position is that you would be comfortable if it had a $0 transfer?
Your Honor, so the agreement that was between me and Holly was she announced that she didn't want to be a parent, basically, but she still wanted to have occasional visits. And so I was fully just basically ready to accept full responsibility of taking on Audrey with 100% coverage on my end. And then just occasionally every once in a while, because I think in the last 6 months, I've only seen her about 6 times for about 15 minutes each. And so I don't feel that really kind of rates any sort of support from her if she's not actually going to be, visiting with Audrey.
Okay. So if I took that amount out and just put it at a $0 transfer amount, you'd be okay with that or not?
Yes, Your Honor.
Okay. So I'll cross that out and I'll put a $0 transfer.
Your Honor, I would also ask the court to enter findings as to the reasons to support that.
Understood. I'll just make a notation here on the child support order in reference to paragraph 10. So to that child support order, I added the following language. The parties agree that a $0 transfer is appropriate as father's income is adequate to support the child and mother's interest in parenting and support is minimal and lacking. So I signed off on that child support order. And on the parenting plan, looks like both parties have signed off and agreed to that. So I'll take a moment to sign that document. There's also findings and conclusions about a marriage. And it looks like has been agreed and signed off by both parties. Sign that. There's also a final divorce order or dissolution decree that has been signed off by both parties. So I'll sign that now. Okay, I've signed off on those orders. I'll check with you. Ms. Russell, do you have any further items or issues?
Could you confirm that the worksheet was entered as well, Your Honor?
I have a proposed child support order as far as a worksheet there's one proposed submitted on July 10th. I could print that and submit it.
It would have been sent on July 8th, Your Honor.
Let me double check and see if it may be in my stack of papers here. Okay, unfortunately, I don't have it. I do have the proposed worksheet that was received and filed on July 10th. Would you be comfortable if I just took that and printed it and filed it?
I accept that the difference between July 8th and July 10th was just processing time, Your Honor.
That's my assumption too. Mr. Clark, do you have any concerns about that?
No, Your Honor.
Okay, I'll take just a moment to go ahead and print that now. Okay, so I'll get that. That's been printed at my break at the end of the docket. I'll grab that and then sign that, and that'll be entered also.
Thank you kindly, Your Honor.
Mr. Clark, do you have any final questions or issues?
No, Your Honor.
All right, those documents that I've signed will be filed and available. If anybody needs a copy, you can check with the clerk's office.
Thank you, Your Honor.
All right, that'll conclude the matter for today. Thank you. 8, Mr. Ellis is present. Come on up, Mr. Ellis. And I'll ask if Mr. Ball, are you on the line, Mr. Ball?
Morning, Your Honor.
All right, good morning, Mr. Ball. All right, we're here today for presentation of order. I've reviewed the proposed parenting plan submitted by Mr. Ellis, and I reviewed the objections by Mr. Ball. So in essence, what I see here is that the parenting plan submitted by Mr. Ellis Mr. Ball is indicating that he's okay with that, but with a few objections. Is that accurate, Mr. Ball?
Yes, Your Honor.
Okay. So having reviewed your parenting plan, Mr. Ellis, there was the petitioner, Ms. Ellis's objections. Did you receive a copy of her objections?
I did. And I also will point out that with those objections, opposing counsel included a July 3rd dated parenting plan, which is not what I filed with the court or had him served with. He has my signature on it. He has it marked as being presented by me. That is not the one that was presented by me.
Okay. I have the one that you submitted that has your signature on it. So
Dated July 8th.
Yes.
Thank you.
Yep, that's the one.
Yes, so I reviewed their objections.
Okay.
And we've already had the section 3B objection here.
Right.
This court ruled on 3B that it was unidirectional from the child to the parent, not a problem of the parent. And in 4 and 14, I've repeatedly pointed out to the court that having a named provider limits my ability to find one that's within my financial means, that works for the child and myself. And both of those named providers have already informed us that they are not available during the court-ordered visitation schedule. And on June 5th, via email, opposing counsel has made it clear that Heidi will not agree to any other time that is not so ordered by the court. So
Okay.
It needs to be clear that there is additional time that fits with the counselor to do those counseling sessions. And I put that in my June 8th presentation and declaration.
And tell me where that is in which paragraph that's where you indicated that additional time for the supervised visitation to occur.
So in my declaration, dated
Well, not
July.
not necessarily your declaration, but the proposed parenting plan. Because that's
So the proposed parenting plan, it's in section 4.
Okay.
And prior to the May 15th hearing, I had 2 evening visits every week with my children. And on the May 15th hearing, you took those away.
right.
I'm asking for those to be restored, and it is listed in section 4 as every Monday, 4 to 8 p.m. and every other Friday, 4 to Sunday, 8 p.m. So the every Monday, 4 to 8 p.m. is a restoration of the pre-May 15th
Okay.
weekly visits. And then similarly, the next section I used to have every Thursday with the older children, I have put it into section 4
Friday.
as every other Friday,
Okay.
4 to 8. I know that's less than what I had before, but
Okay.
that's what I can do.
Mr. Ball, with regard to, I'm working off of Mr. Ellis's July 8th proposed parenting plan. Do you have a copy of that? Can't tell if he's frozen. Looks like.
Oh, I'm not frozen. I'm looking on
Okay.
to make sure I have. I thought it was the same thing. I don't know. The one that I have, let's see, was, oh, okay. That was not the one that he submitted. I'm not sure what the difference is. Let me just look then.
Yeah, I think
That is the
Mr.
only difference.
I think Mr. Ellis indicated that the difference
Cool.
is that for the 3 younger children, he added every Monday 4 to 8, and the 2 older children, he added every other Friday from 4 to 8.
Oh, okay. I see what happened then. Yeah, no, okay. Yeah, my client doesn't agree to that.
Okay. So with regard to Mr. Ellis's concern that the providers, the professional supervisors don't work on weekends, and there's a provision that would allow Mr. Ellis to use a professional supervisor to provide feedback. Do you have any thoughts on that?
Well, that was my understanding, is that it would be supplemental to his regular parenting time. That's the way I thought. That's the way it had been written up, and
Okay.
so it would be. So I guess you could, if you want to clarify that, or that should be clarified, that it would be in addition to his other parenting time. I mean, I didn't mean to make it so his regular non-supervised parenting time would turn into supervised parenting time. That wasn't the intent at all. The intent is for him to have his parenting reviewed, so that and then to set a review date if he wanted to, so the court could hear from the supervisor.
Okay. All right. So this is kind of what I was thinking, is that Mr. Ellis indicates that, his concern is that the court has reduced his time, and that there's a 12-day period that goes between certain visits with certain children. And so his concern is that he wants that restored, so at least there's some greater contact, and that's also tied to the potential for having that supervised visitation during those periods is kind of my sense. So in looking at the proposed order that Mr. Ellis has submitted, it adds for the younger children every Monday from 4 to 8, in addition to the alternating Fridays to Sunday, which are unsupervised. And then for the older children, it would be that every other Friday from 4 to 8, in addition to the Sunday, and still with the older boys opportunity to opt out of those times. I'm fine with that, so I'm going to go ahead and include that, because those would be opportunities to, one, lessen the amount of time in between, and it would also allow for that supervised visits to occur. Those supervised visits to occur. The next portion, so I'll leave those in as proposed by Mr. Ellis. The next portion I wanted to address was the proposed supervised visitation language that Mr. Ball included in his proposed language, that indicates that it be a named professional supervisor, Ms. Fellows. Mr. Ellis, are you okay with that, or you just want it to be maybe blank and say a professional supervisor.
I think just that strike the name,
Okay.
leave those three places where it names Beth Fellows. I mean, I
Mhm.
like Beth Fellows and all, but I got to get on her schedule.
Mhm.
So take her name off of there, leave it as professional supervisor, and the professional supervisor's office where it lists down below that the first visit shall be at Beth Fellows' office. And then at Beth Fellows' recommendation, you change to the supervisor's recommendation.
Okay, so in general, you're okay with that language, but just the proposed language by Mr. Ball, but striking Miss Fellows in every instance and just leaving it to be at the professional supervisor's office, if you will.
Yeah, I recognize that it's an entirely optional section, but also that this court didn't follow the gal's recommendation and has now placed that additional roadblock, so I'll take advantage of it.
Mr. Ball, any concerns if we strike Ms. Fellows' name from the proposed language?
I just got minor concerns. I think that's what we had kind of agreed to use her, but if he doesn't want to use her, if he wants to find a different one, I guess that's fine. I guess. I mean, that schedule that I wrote in there is one that Miss Fellows had recommended. That's what the amount of time she would need to have to be able to do a review, I think is. So that's fine if he has another professional supervisor. I don't.
Okay. And then Mr. Ellis, from your vantage point, that proposed language, that kind of sets out some timeframes for a period of 2 months, number of visits, and a period of 1 month as a number of visits. Do you have any concerns with that language? And I'm looking at specifically.
I don't think I did. Let me just look.
Yeah. It says the schedule for the professional supervisor would be for at least 2 months. Father will have 1 weekly visit of 2 hours or more, followed by 1 month of 2 visits per week, of visits of at least 2 hours in duration.
Yes, that was all fine.
Okay.
And do understand, I'm not against Beth Fellows. I just got to find one I can afford.
No, there's some flexibility by just saying professional supervisor.
I would ask that the court continue in Mr. Ball's piece there where it's got some blanks.
Mhm.
We had talked about the frequency that we were back here, and I would like to have some sort of pre-approval that we're going to be back here on a particular date for review.
Do you have a proposed date for that review? Because with the kind of the schedule that's listed above, it talks about roughly a 3-month, looks like a 3-month period, because it says for 2 months and then for 1 month. So 3 months from today would be what, October? Let's see, July,
That's
August,
assuming
September,
I could
October.
find one and get started right away. So let's, would it be okay to say, what's 4 months?
I mean, in a week.
Yeah, 4 months. Let's see, let's look at the calendar here. So we have July, August,
That's not 12 days.
September, October, November. So November would be 4 months because November is the 11th month. We're in the 7th month. So we could look at a Wednesday in November to review it. The 20th is the
Sunday.
there's a potential I'm not going to be there during that time frame. So we could either look at the 13th. I'm absent also. So we could either look at a review date of November 6th or the 27th of November. Those would be 2 optional dates, or potentially December 4.
Let's do November 27th, please.
Mr. Ball, November 27th, how does that look?
That should be okay.
Okay, so we'll set that date therein, which will be November 27th, 2024 at 9 a.m. for the review. And so let me just ask, Mr. Ellis, do you have your proposed, most recent, the July 8th proposed order? Do you have that in Word format that you
I
can
can
forward?
get it to you in Word format. I did not.
Okay.
Yeah, I printed it off for the court here, but
Yeah, that would be helpful because what I can do, if Mr. Ball, you could send me your objections document in Word format and then send a copy to Mr. Ellis. then I would have that and I could just copy and paste with the few adjustments we've talked about here today. And then Mr. Ellis, if you send me your proposed July 8th parenting plan, then I can take that language, fit it into what you've prepared, and then just make those adjustments we've made today.
You had also intended to address the cost distribution on this section.
Sure. Yeah. We're not done reviewing. There's a few things we still need to review, but I just want to make sure. Do you have Mr. Ball's email address?
I do. How would I email you?
Evans M. So last name Evans, first initial M as in Michael, at cowlitz.wa.gov. So cowlitz.wa.gov.
There was no period between the Evans and the M, correct?
Correct. And Mr. Ball, do you have Mr. Ellis's email address?
Yes, I do.
Okay, great. If at all possible, if you could get that to me before close of business today.
So you want me to send the objection language to you in Word format?
Please.
All right.
Yeah, be great. Okay, great. Then the last portion of that proposed language is related to cost of the supervision. Mr. Ellis, did you want to address that?
Yeah, I would like it specifically identified. The opposing party has made it clear that she will not do anything that's not ordered by the court. So ambiguity is not good. And this says any cost of supervision must be paid by John Ellis, which is definitely not ambiguous, but it also doesn't follow the 38% John Ellis, 62% Heidi Ellis proportional share that we have in our family support order.
So your proposal is to, rather than you pull the full freight or pay the full freight, that would be the proportional share as based on child support percentages.
That would be my request.
Okay. Mr. Ball.
So Mr. Ellis should pay the cost of the supervision. He's the one that is benefiting from it. I've heard other attorneys say that, it's his fault that he's having supervision. I don't agree with the fault-based language of it, but in some sense, it's for his benefit. My client, I think, I don't think she's working right now. She's attending school. She's taking care of the children full time. So I know both parties are financially strapped here. But I'd request, I think normally it's the person who has the supervised parenting time has to pay for it. And since it's also discretionary and asks that it's not even that much of a burden on him to pay for it. So.
And I object that it's for my benefit. This is for the children's benefit. It was recommended by the guardian ad litem not to have paid supervision. That's what we've been doing. And now the paid supervision has been offered as a way to remove the supervision altogether, which was best for the children. It's not just for my benefit.
Thanks to both. Let me ask when the court made its decision on the cost of the optional supervised visitation, did the court make a ruling of who would bear those costs on that date back in May?
No.
The court had to look at the court notes. I don't recall. This is our 4th or 5th hearing on this, so I don't recall.
Bit of it. I'm just looking back.
I'm very clear that no order was made on the distribution of payment until the very last hearing, when you assigned 60% of the reunification counseling to me. And I specifically asked about the professional supervisor, and you said you wanted time to think about it, and that would be today.
Thank you. Mr. Ball, any input on that procedural or the procedural history?
I think that we were going to address it today. I tried to address it last court hearing, but that was opening too much of a can of worms. So I think it was reserved for today, so it wasn't ordered.
Mr. Ellis's rendition is accurate. So two different philosophical views of the parenting plan, the supervised, the cost of the supervisor. One theory is that it's benefiting Mr. Ellis. It's a means by which he can manifest his parenting and have that report reviewed by the court to adjust the parenting plan. The other school of thought is that that supervised visits is for the benefit, really it's kind of a holistic view in that the child is benefited, the parent is benefited, and when the child and the parent are benefited, then the whole family is benefited. Here in large measure, that supervised visitation kind of at its root, its basic purpose is to allow for Mr. Ellis to kind of push back or paint a different picture than what maybe the court has decided. So that comes, obviously that's a benefit, I think, for any parent that wants to have more time with their children. That's something that they're interested in, that's a benefit that comes to them. And obviously with that benefit, that has the dual purpose of, with more time and reunification counseling, and if all that works out, then the family is more cohesive and there's tighter union. So kind of both camps are fulfilled by the costs of the supervised visits. I think it weighs more heavily in that the benefit is maybe greater to the first camp of Mr. Ellis. And so I'm going to require 80% for Mr. Ellis and 20% for Ms. Ellis. So that language here that's proposed by Mr. Ball, maybe Mr. Ball, when you make that your edits, and Mr. Ellis, you're free to do this in your July 8th submission if you want to amend it to reflect that the costs will be split 80% Mr. and 20% Ms. Any other items? Then I guess the next item is the use of Barbara Brandhorst as the reunification counselor. Any concerns with that language, Mr. Ellis?
Yeah, same as the previous one. I would just like to strike the quoted part that says the parties shall use Barbara Brandhorst as the reunification counselor, father, and Joseph Ellis. Other than that,
okay.
Father will comply with the counselor's requirements. The counselor may suggest a parenting schedule for Joseph Ellis. It's fine.
Okay.
And I did already have the reunification counseling included in section 14 of the one that I presented. So,
right. Okay. Mr. Ball?
I'm just reviewing the language that I think we got. Oh, okay. I don't know. I don't recall why we had Barbara Brandhorst. I know that's who they used before. Sometimes it's helpful to name a person in there, and so we know it's sometimes hard to find a reunification counselor. But I guess if there's another one that he wants to propose that does that, I don't really have an objection to it.
Okay. Yeah,
who's ever going to be successful, I think, is probably who should do it.
Sure. Yeah, I'll strike the language, the name of the specific counselor, Barbara Brandhorst. I'll strike that, and in its place, it should read the party shall use a professional reunification counselor, or credentialed or licensed or something along those lines.
Okay.
So I think that addressed all the issues in the objections. Anything that's been left undone, Mr. Ball?
Your Honor, I did want to, and I'm sorry I had to revisit this, but I feel that, the change in the regular parenting plan, I wanted to address that because that is what, the way we had proposed it is what the court order. And so to shift it there, I just want to bring my client's concern to the court again, is that, she feels that the current schedule is working, that that it's not in the children's best interest to add that extra time on the Monday there because it kind of interferes with their schedule. There's already some reluctance that she's having to deal with, and then children go into the parenting time, and it kind of interferes with the schedule, the bedtime routine that she had set up. So she does have some concerns that she voiced to me that we didn't have a chance to bring up. So sorry to bring that up again, but I wanted to raise that.
Well, that's important to hear your client's concern. Thank you, Mr. Ellis.
No, I thought we'd already covered it, that this was part of their regular schedule already prior to May 15th. And the children have expressed problems with the new schedule to me because they don't see me for nearly 2 weeks. It's 12 days between when they see me and when they see me again. They leave on a Sunday and they don't come back till Friday, 2 weeks later. It used to be that we got to go do fun stuff on Monday nights, and we can't do that anymore because these are not available on weekends. So I don't see this as adding time for the kids. I see it as restoration of time that was lost in their previous schedule.
Okay. All right. Thank you.
Can we make it an every other Monday or something like that? So we're concerned about the, the length of time in between. And plus it would be a Monday, it would be a Sunday, and then the next Monday, on his every other weekend. So, you know what I mean?
Yeah, I appreciate
Another
the
transition.
Yeah, I appreciate the perspective of both parties. Yeah, there's no perfect schedule when two parties have separated. So I'm going to leave the language that included the Monday for the younger kids and the alternating Fridays for the older kids. All right, so I'll look forward to the emails from both parties, and make sure you see when you send it to me. Make sure you're CCing the other party.
And will
Right.
those, sorry.
So I think that concludes the order on the presentation. Mr. Ball, anything else?
No, thank you, Your Honor.
Mr. Ellis?
Yeah, the reunification counselor has indicated that they need a signed court order in order to begin counseling. Is this something where we got to come back again in a week, or are you going to do it ex parte and email it back, or how's that work?
Yeah, what I'll do once I receive the proposed different documents from each party, I'll merge them into one using Mr. Ellis's proposed parenting plan as the base, and I should have that signed today, and it'll be filed so the parties. And if you'd like, I could email a copy to both parties.
I would appreciate that.
I'll get myself a note and then. Okay, I'll do that. All right, that'll conclude things. Thanks.
Okay, thank you, Your Honor.
Good morning, Your Honor. This is Brandy Jeffers. I'm coming in on number 2, the Kanata and Thomas matter. It is going to be a request for a continuance, just whenever you're ready.
Okay, we can go ahead and take that right now since it'll be brief, and then next we'll take the Keegan Trotter matter after that.
Thank you, Your Honor.
And we have, Ms. Jeffers, you're going to be filing a notice of appearance on behalf of
Mr. Thomas, Your Honor.
Mr. Thomas. Okay, is Constance Sonoda, are you on the line today? See, I see for the record, it should be noted that Mark Thomas is on the line. Oh, and it looks like Constance Sonoda is on the line, but she's muted. Still muted.
I can't get unmuted. Hold on, I'm trying to figure it out.
You did it. You're good. Okay. So you were unmuted and now you're muted again. Yeah, it looks like you were successful there. Okay.
I can't figure it out, Your Honor.
You're good now. Oh, you were good for a second there. You pressed a button just recently that was good. So there you pressed a button that just let your camera on. You're still muted. Look for something that has there you go. Don't touch anything. Oh, wait. Well, it says you're unmuted, but now I can't hear you. You can't hear me. So maybe, Ms. Sonoda, let's try that right there. Can you hear me? All right, so you can't hear me. I can't.
Can you hear me?
Yes. Don't touch
Okay,
it.
now I got you.
Okay, great.
Sorry about that.
No, it's okay. So we're here today on Ms. Sonoda's motion for adequate cause. Ms. Jeffers has indicated that she'll be filing a notice of appearance on behalf of Mr. Thomas and would like to respond to the motion. And she's asking for a continuance of what period of time, Ms. Jeffers?
Well, Your Honor, he was served out of state. It looks like that was on June 27th. Generally, there's 60 days. At this point, the earliest that I could possibly have a hearing is August 6th. This will move to the attorney docket. Not sure if that's going to be A or B. That is where I am.
Okay. Ms. Sonoda, what's your perspective?
I tried to have him served. I was told that the address that was on the last set of paperwork that he filed to change the parenting plan. I was going to send it to him, that address, and have a court date initially in June, but child support told me that that was incorrect. And then I had to fill out all this paperwork to have his address, the updated address, submitted to me. And then it was the exact same address that I had initially. So it just kept postponing it. I guess if we have to continue again, then it is what it is. But I did the best that I could to get him the paperwork in a timely manner.
Okay. All right. Thanks, Ms. Sonoda. Yeah, service sometimes is tricky and sometimes it's difficult. And it looks like service was effectuated on Mr. Thomas on June 24th. And generally it's a 60-day time frame if a person's out of state. And it looks like Mr. Thomas is out of state. So we were looking at potentially, end of September. Ms. Jeffers has indicated a shorter period of time would work for her and her client, which would be on that August 6th date, which is a Tuesday. And Madam Clerk, do you know which docket that would be on potentially? Sure. I think. So it'd be in the afternoon. So at 1:30 in the afternoon on the 6th. Making sure if everybody would be available on that date and time. Tuesday, August 6th, 1:30 p.m. At 1 p.m., sorry.
Yes.
1
that
p.m.
Okay, I think both Ms. Jeffers, you said yes, correct?
I did, Your Honor.
Okay, and Ms. Sonoda?
Did you say 1 p.m. or 1:30?
I said 1:30 and then I was corrected and it's 1 p.m.
Okay.
1 p.m. Okay. So it sounds like that'll work. That'll allow the court to, I know what Ms. Sonoda wants, and then the court will be able to know what Mr. Thomas wants, and so we'll have full input from both parties, and we can make a decision on August 6th at 1 p.m. So that's when we'll next reconvene. Any
Thank you,
questions from you, Ms. Sonoda?
Thank you, Your Honor.
Okay. We'll see everybody there. Thanks, Ms. Jeffers. Thanks, Mr. Thomas, for joining us.
Thank you.
All right, that'll conclude the matter. Thank you. Both parties are present. They're coming up. Okay. So let me just touch base with the parties. Once you get settled, I'll just do a little prelude here. I have proposed orders for a final order and findings. I have a proposed parenting plan, child support order, and also worksheets. Looks like they were signed by Ms. Keegan. I don't see a signature on any of the documents from Mr. Trotter. So I guess I'll just hear from the parties. Where are you at?
So I turned in that parenting proposed final order last week because as of that date, he didn't have anything he needed to take
Okay.
Brooks. I kept asking him about it. It was kind of like pulling teeth, but the last few days he got a car seat. He's still working on getting the rest of the stuff, and he said that he will be open to taking him starting next week on Wednesday.
Okay.
So I brought the other parenting plan that we were originally going to turn in. He hasn't signed it yet. I don't know if he still wants to take him next week, we can just sign the one that we have here. It's all filled out and everything, but.
Okay, thanks, Mr. Trotter. What's your
Yeah, pretty much the same thing. I wouldn't really say it was like pulling teeth. I just spent a bunch of money getting caught up on other things and paying off the Home Depot card that we had, that and she was saying she was going to take me to small claims court and stuff like that. So it wasn't necessarily like pulling teeth, but yeah, I've started accumulating more of the things that I need. And we're pretty much in agreement on things she said. I think she submitted a different one, but we decided that she doesn't want to do that one. And the one she has right now, I'm okay to sign and turn in with you. And I think that we both signed the child support amount that we agreed upon as far as that goes. So.
All right. So okay. So this proposed parenting plan that I have in my hands right now, I'll give that one back to Ms. Keegan, and then Mr. Trotter, if you want to take a look at the parenting plan that Ms.
I think we
Keegan
kind of
has.
looked at it and talked about it a lot.
Okay,
actually.
so if you feel comfortable,
Yeah.
and you can sign off on that.
The bold piece, but
And then I'll hand this down to the clerk. I want Mr. Trotter to look at the child support order and the worksheet and just review that to see if you're comfortable with that, because you indicated that there's a degree of comfort with that, but I just want to let.
Her and I had agreed on the child supporting out and signed that one.
Yeah, I can double check to see if that was entered.
And she told me she turned it in.
Yeah,
So
and that may be it. That may be the document right there that she turned
Okay.
in. So
That one
just,
we signed the one that, the final one. So your signature should be on the back page.
and the ones that I have there, I only saw Ms. Keegan's signature on those child support documents.
Okay, I turned in the final one that we both signed with the final parenting plan
So the
on
documents,
Thursday.
so the documents that I was handed only have your signature on it. So I'm not sure what.
I know this is the right one for this stuff.
Okay.
So we agreed upon for
Wait,
this.
make sure it's right, because they're
I
that
read
little
it, yeah,
bit
no, this is
different.
the one for this is $600.
And the percentages and everything
Yeah.
are right.
but we-
Yeah, and you can look at it after he's reviewed it and he's signed it. You can take a
I'm
look at it
sorry,
to make
yeah.
sure you feel comfortable with your signature on it. And if I don't want to have anybody feel pressured, because you're kind of in the hot seats right here. I don't know if it'd be better if you want to just take a look at the documents and then sign them. And then I'll call a case and then come back to your case.
Yeah, whatever you think. We talked about this stuff pretty much like ad nauseum almost. We just hadn't put
Okay.
signatures to it really. So, but if that's,
I'm fine then.
we don't want to hold you guys up or take any more time. So if you want to,
I'm fine just taking a few moments right now.
I was going to sign this, but where you handed it to me, it says sign here. It says judge or
Go to the
Commissioner?
page right before it. There should be a location there. Generally, the parties sign before where the judge signed.
this one I signed here.
Yeah, that's perfect.
Okay.
So then I'll just sign the rest. So that's this. So I'm signing off on the child support order. And then there's the parenting plan and the worksheets if you want to take a look at those.
And Your Honor, I have a question about the child support order. I did check on the page for I think it was DSHS to just automatically take the payment.
Uh-huh.
I don't know if that's something that has to be approved, or I don't know if.
If it's part of the order, then it would be a court order. Then the payment would go through that third party division of child support. So if that's what.
And that was the one with both of our signatures on it.
Confirm
I think
that.
it was, it had your signature already. Okay.
Is that a signature? Isn't it?
Okay, let's see.
This one you like the white out stuff. That's right.
So the payment method is paragraph 14. It says registry and it was marked, and then there's like a little wisp of whiteout going over the middle of the X.
I was a little confused. I don't know if did I not check it correctly?
If it's a bit ambiguous. If you want it to be in there, I could make it clear and just make sure the X shows that the payment should be sent to the registry of the child support.
Yeah, I'd like to do it that way, just in case, so there's no
Okay.
conflict in the future.
Mr. Trotter, do you have any questions on that? Just basically the payment would be sent to the Division of Child Support. They log it and then they forward it on to Ms. Keegan.
Yeah, I don't care. It's not, I'm not gonna not give her money or anything. I don't like,
Yeah.
I've already given her money. It's not like I'm gonna stop, before I was even ordered to, so I don't care.
Okay.
Whatever makes her comfortable or you guys comfortable or whatever it is.
I'll include that it's the payment is to be sent to the registry. That provides a nice accounting for everybody and it
Yeah.
resolves a lot of issues
Okay,
or prevents a lot of issues.
sure.
Okay, so that's included there. And so I've signed off on the child support order. Yeah, and then Ms. Keegan, did you want to review the parenting plan to make sure that's the one you were thinking it was? And then Mr. Trotter, while you're up here, there's this other document. It's just kind of a overall summary order. Why don't you take a quick look at that? You can come on up and grab it. Thanks. Oh, and then Ms. Keegan, did you want to look through the parenting plan also? Did you look through it?
Yeah.
That one you're good with? Okay.
What is this one for?
I think that, tell me, read the caption in the top right underneath the cause number, so I know what you're talking about. Is that one, does it say final dissolution?
Final order and findings for a parenting plan?
Yeah, it's basically kind of a summary document that just goes and says, hey, the court's ordering child support, the court's ordering a parenting plan, the court's.
But we just turned in both those things, right? So that's what, when
There's
I
two.
sign this, that's what it says. And we just did.
There's the parenting plan, the child support order, and then the final order for parenting plan and child support. So that's for both of them right there. That's just.
Oh, so that
finalizing it.
was like what we're gonna do, and then this is like.
Yeah, there's some, it's kind of like an overarching document that says that the court's signed a parenting plan, the court signed a child
Okay,
support.
so basically, it's like says that I did sign the other deal, and it's like the final, like approval one, and so we do.
Yeah.
That's-
Okay, just so you know, Mr. Trotter, I'm just going to go through this kind of this summary document so it's clear in your mind and
Okay.
you feel comfortable with it. So it says that there's not a money judgment being ordered. Sometimes like in a divorce, there's debts assigned to person X or person Y, and they have to pay this, or they have to transfer X number of dollars to another parent. We're not doing any of that here. So it just says we're not doing any of that.
Okay.
It says that the court made a decision today about the parenting plan and the child support. This all the orders pertain to Brooks, who's will have a first birthday soon, but not too terribly soon, but he's young still. And that their parentage is present, and that the indication is that the Brooks was born in November 12th, right? Is that correct?
Yeah.
November 12th. And so it's indicating that you're both saying that you're the parent, so there's no question there. And that the acknowledgement of parentage was filed in the state of Washington, and the deadline to change to say, hey, I'm not the father, that's passed. And then you're also indicating that there's no acknowledgement of parentage from another state. You're indicating agreement that Ms. Keegan lives in Washington and that you live in Washington State, and that the court has jurisdiction over the parenting plan. And that because Brooks has lived here his whole life, he hasn't lived in any other state, so we have jurisdiction. And that the court today signed a parenting plan, and I'm just going to change the date, so it's today's date, the 17th. And that the court signed a child support order, which that's true. I signed that today. Nobody asked for a protection order. There's no protection order being put in place. There's no restraining order being put in place. Each party pays their own costs and fees, and that the court signed off and approved a parenting plan, a child support order, and that this is a temporary parenting plan. It's not a final. So a lot of parents will work under a temporary parenting plan forever. If one parent doesn't like a parenting plan, a temporary parenting plan that's been put in place, then they can ask that it be set for a trial, and then there'd be a full hearing on the parenting plan, and then a final order would be entered.
I have a question about these things, sir.
Yeah.
I think this is the same one that I just signed and turned in, a different one. Right, the order and findings for a parenting plan with the schedule and child support, right? That's the one that I just signed.
Yeah, and that's the one that I've just been reviewing with
Okay,
you.
so
Yeah, that's fine.
This one is the one where she put her,
Her income.
yeah, income and stuff.
Mhm.
What do I do with this one? I've already submitted my own. I just signed it, says that I saw all her financial.
Yeah, because on your child support, I think does it list on the child support order your income?
No, that was not there. I submitted it separately.
Okay. And you agreed that $600 a month is okay. Okay. You can just sign off that you've been acknowledged that you got hers. Yep. Okay. That. And then just finishing up on kind of the summary document order, I just want to make sure I was just in the process of just finishing up reviewing that so you know exactly what it says and what it's covering. So this summary order says that today the court signed a parenting plan and a child support order, and that there's no money judgment and there's no other orders. And so that covers that kind of the overarching umbrella document. So I'll sign off on that. Do you feel comfortable with that, Mr. Trotter? Any questions on that summary document?
No, you're on.
Okay, all right, so I'll sign off on that. Just for sake of completeness, Ms. Keegan, if you look, the parenting plan that Mr. Trotter signed and I've signed, do you want to, if you feel comfortable, get your signature on that one? It's one document we kind of missed there. Okay, well, I'm glad we invested a little bit of time. It sounds like the parties are agreed. We have all the documents signed. And so I really appreciate both of your efforts. You know, that bodes well for your child as you co-parent in the future, and just working together is going to do nothing but help your son grow up healthy and happy. And that's what I think you both want. So got them signed. If you need copies, you can check with the clerk. Couple days, they can get you copies.
Good to go.
Good to go.
Thank you.
All right.
Thanks,
Take
Your
care.
Honor.
All right. Thanks. It looks like this is on today for a presentation of some final orders. I'll let you know what I have in my possession. I have a child support order and a child support worksheet. I also have a proposed parenting plan, and I also have that summary document, a final order with findings for a parenting plan and child support. So I have those documents with me, and in reviewing those. We'll start with the parenting plan. It looks like Ms. Herring signed off on the parenting plan. Mr. Brimmer, I don't see a signature on it, nor with, I think.
No.
Documents.
Sorry.
Yeah. Right.
Go ahead. Sorry.
No, that's okay. That's okay. I was just noting which signatures are there and which are not. And so there was a default order that was entered back on, let's see if I noted the date. I didn't, but it looks like a default order was entered in behalf of Ms. Herring, and that was entered on April 19th of 2024. And so thereafter, what Ms. Herring has done, she's taken her original pleadings and her proposed parenting plan, and she's mirrored that with what I have here. And then it looks like because the specific items of the state of the child support were not provided in the initial pleadings, then she sent a copy to Mr. Brimmer of what those proposed order child support worksheets and child support order would look like. So that kind of brings us to where we are now. So anything to that? Go ahead, Mr.
Yeah, I was going to ask if we could try to get this pushed out just a little bit longer so I could try to take some time off of work to get I don't know what you call it, some paperwork turned in to go against what she's trying to do, because I don't agree with any of it. I have been sending her $200 every single week since I think mid-February. Before that, I was paying about $60 a week for a couch that I bought her before we split up, and on top of that, also giving her $150. She said me paying for the couch would cover for the remainder of the $200 for child support every week. So any back stuff is probably not really true, because I know it said that I owed her like $4,500 or something like that. But like I said, I've been sending her $200 every single week since February, and I have all the records to prove that. So I need a little more time to actually get some paperwork filled out. And I noticed that she put down that I had a substance abuse problem, which is untrue. Almost everything that she has checked off is untrue. So I just haven't had time to take off of work. I can't afford it, but since it's come down to this, I'm gonna have to now. And yeah, if I can just get a little time to get some paperwork filled out and turned in, that would be super amazing.
Okay.
Can I say
Yeah,
something?
go ahead.
So there's been multiple times where there's been a long period of time because of his own reasonings why he hasn't sent child support. I just want it to be a consistent thing controlled by the courts. Another thing is he's only been worried about the money. I don't care to put
That's
out
not true.
a continuance on the child support, but the parenting plan I do want to figure out, just because the last time he had him one time in the last 10 months, he wouldn't give him back. The cops had to be called. There was a CPS case because he put him on a dirt bike, and he's 2 years old, and he got a severe
Wasn't
burn.
riding it by himself.
Oh,
He's-
hold on,
I
Mr.
just-
Brimmer, just please remember, I didn't announce the rule at the beginning. Just when one party is speaking, I let them speak without interruption. If there's a legal
apologies.
objection, you can make a legal objection and interrupt. But if it's just disagreement with somebody's statement, then just hold that disagreement till it's your turn. So go ahead, Ms. Herring.
I mean, when it comes to the child support, if he wants to fight the back pay, I don't really care about that. That's not the problem. I just want to figure out the parenting plan, most of all, because I think my son is like better in my care unless he is going to take these classes, because there's like that one day that he had him in the last 10 months, that was all because he decided to drink on the one night he had him in 10 months, which resulted in the cops being called in a CPS case. So yes, he does have a substance abuse problem. I don't want to go back and forth with him really on it. I just want it to be set in stone. If he really cares enough, he'll take the classes that he needs to take so he can see his son,
Okay.
to be a better him for our kid.
Okay, thanks. Okay, so Mr. Brimmer, where we're at, and I'll hear from you, is that there was an order of default entered in back on April 19th. And so default orders are entered when one party files some documents and they say, hey, this is what I want. In this case, I want Ms. Herring, she wanted a parenting plan. So that motion, because nothing was filed, the court entered an order of default, meaning the requests that Ms. Herring made in her initial petition were granted. And that's the rationale behind that, is that sometimes when somebody files a suit or a petition for something, the other party says, I'm okay with that. And I'm not even going to take the time to respond to it because I'm okay with it. And I don't know if that was the case here, but that's one rationale of why that rule is in place. And so with the default order, she's required to mirror the exact petition that she requested initially as far as the parenting plan, and that's what she's done. So as far as the parenting plan, I'm signing off on that parenting plan because there is a default. Now, if Mr. Brimmer, if you feel that default order was erroneously granted, you could certainly file some type of motion to vacate that, but that hasn't happened at this point. So I'm going to sign off on the parenting plan today. So the other.
Should I get some info? Sorry.
No, go ahead.
Can I get some info about how to go about that?
So legal resources that are available generally, you can look at washingtonlawhelp.org. Washingtonlawhelp.org is one option. You can also check with Northwest Justice Project. I think they actually run the Washington Law Help website, but that's so washingtonlawhelp.org. Look under family law, and then then Northwest Justice Project. They may have some resources available to you. And these are resources available to anybody. There's also the CLEAR hotline, CLEAR, CLEAR hotline. It's a hotline staffed by Washington licensed attorneys who provide legal advice to persons going through legal proceedings. There's some income limits on it that either party can, you can do a quick Google search and find CLEAR hotline, and that can provide some direction.
Okay, thank you.
Any questions, Mr. Brimmer?
I don't think so at this time.
All right. So what I'm going to do, based on the default order and then the parenting plan that is a mirror image of the petition that Ms. Herring requested initially, I signed off on the parenting plan. And then as far as the Child support's a little bit different here in that Ms. Herring requested child support, but there weren't any specifics. And now she's provided some specifics and provided a copy to Mr. Brimmer, and Mr. Brimmer's indicating that he's in disagreement with that. So I think the default needs to at least have some opening there for the child support to be heard and decided. So I'll just talk to the parties about that just briefly as far as setting a date, because if Mr. Brimmer wants to submit information related to his income and what he thinks the support should or shouldn't be, he should be able to do that, submit his documentation to the court and provide a copy to Ms. Herring, and Ms. Herring would have an opportunity to respond to that. So that so we need to take a look at a potential time frame to do that. Mr. Brimmer, as far as your timeframes, you talked about taking work off and the like. So I'm looking at a potential hearing, probably 4 weeks, maybe 4 to 6 weeks, where the parties could work on that, and we could come back and have everybody's voices heard and make a decision on the child support. So Ms. Herring, as far as your vantage point, what do you think about that? 4 to 6 weeks.
That sounds good to me.
Okay, Mr. Brimmer.
Yep, that's fine. I only need 2 weeks in advance to take time off of work. So.
Okay, so today we are the 17th. 4 weeks would be the 14th of August. 6 weeks would be the 28th. Any preference between August 14th, Ms. Herring, and the 28th?
No.
Mr. Brimmer, any preference between the 14th and the 18th?
No, Your Honor.
Let's set it for August 14th then. August 14th will be the hearing on the child support issue. So Mr. Brimmer, if you want to submit your side of the story, then you would need to submit declarations and proposed worksheets and proposed child support orders, file those with the court, and then provide a copy to Ms. Herring. Generally, that can be accomplished by U.S. mail.
Okay.
All right. Any questions?
No, Your Honor.
All right. Any questions, Mr. Brimmer?
No, Your Honor.
All right. We will see everybody on the 14th of August. That'll be at 9 o'clock in the morning. All right. Thanks.
Thank you.
Ask if Maggie Sills, are you on the line today, Maggie Sills? Next, I have Maggie. Not hearing a response. Ms. Sills, if you are on the line, make sure you're unmuted and state your name, please. I'm just looking in the participant list for a Maggie or a Sills or something similar. I'm not seeing it. And nobody's in the courtroom responding to the name. Bradley Sills, are you here? Bradley Sills?
Yes, Your Honor.
All right, Mr. Sills is present, and we have Ms. Height also. Welcome to you both. We are on today for a motion to transfer the case to mandatory mediation and a motion to admit the guardian ad litem report. These are both filed by Mr. Sills. So Mr. Sills, I just want to just touch base with you to make sure I'm clear on your motion. Well, first off, service upon the mother was effectuated on June 29th. There's been no response from Ms. Sills filed. Has either party had any contact with Ms. Sills in response to the motion, Ms. Height?
I have not, Your Honor.
Okay. Mr. Sills, have you had any contact?
I have not.
Okay. So your motion to transfer the case to mandatory mediation, it sounded like that was what you're asking for, and I've got an proposed order to that effect that would transfer it to mediation. But then I thought there was something in your declaration that says, you weren't sure that mediation would be in the best interest of the child. Mom didn't participate in the investigation by the GAL, and you wanted to waive or skip the mandatory mediation. So I'm a little confused on what you want. Tell me what you want.
Yes, Your Honor. It was my understanding that the motion for mandatory mediation was the next step in the process.
Okay.
But I didn't see any way to file like a motion to waive mandatory mediation.
Okay.
So I wanted to schedule this hearing just to kind of ask, because I saw that it's in the court's power to waive mandatory mediation based on her lack of ability to show up or present herself, give any type of communication. I feel it's in the best interest to waive mandatory mediation. It doesn't seem like it's a practical step in the process. I'd
Okay.
like to ask Ashley's guardian ad litem and Height to put some input into that as well.
So your request, just your clarified request is that you want to waive the requirement of mandatory mediation, say, not necessary, we can pass over that step and then move to the next step after that.
Yes, Your Honor.
Okay. Ms. Height, do you have any comment on that?
That seems reasonable, Your Honor, as if you looked over my report, the amount of contact has been, except for the very beginning, completely ineffective. I've tried various things and have had no success whatsoever. I have here the returned mail that she that shows return to sender, not deliverable, as addressed, and I've been able to get no messages through to her. So, and in addition, just one quick housekeeping add-on, she also has not participated financially and is currently paid nothing on her $1,950 fee that is due me.
Okay. All right. So I will waive the requirement for the mandatory mediation. I have that proposed order that required transference. I'm just altering it a little bit. So I'm retitling it to order waiving mandatory mediation. And the order reads, this matter having come on before the court for hearing and appearing that certain differences have arisen between the parties in accordance with CCLCR 93. Now, therefore, it is hereby ordered the requirement of mandatory mediation is waived. So that's basically, and then I'm just striking everything else on that order. So it's just waived. So I'll finish striking the rest of the language.
Thank you, Your Honor. How do we proceed? I have a couple more questions for you. I was curious, do I need to make an appointment with a courthouse facilitator at this point?
That's definitely an option that you have, yes.
All right. And what other documents do I need to serve her with, since she isn't here and she's essentially disappeared? I don't know what other documents I need to serve her with, and do I still just serve her to the address and make the attempt like I did this past time?
So next steps as far as like what documents that you need to file, I'm not able to tell you that. That would be legal advice. I can give you options that you can check with the courthouse facilitator to review any documents or pleadings that you've prepared. You can also look at washingtonlawhelp.org. That's an explanatory website with also court forms that you can use. It's a good resource. And then there's one other thing I was going to mention.
So I do have the final divorce order, child support worksheet, child support order, final parenting plan order, and notice of intent to relocate ready to file. Is my understanding I have to have this hearing before I can file those, though?
Okay. Yeah, if you have additional motions for parenting plan and child support and the like, then you could file those and serve copies upon Ms. Sills at the address that she provided in her pleadings. And I think that we've got the address that you served her for today's motion is the Silver Lake address.
That's correct.
Okay.
So I just continue sending the motions to that address. Is that correct?
Yeah, so at this point, the idea is that due process needs to be given. So in other words, that's notice. Any party that's is subject to litigation, they have to be given notice of what you want. So you have to let them know and serve them documents and then file proof of service or a declaration of service. And then we'd have a hearing where she'd have an opportunity to present evidence or present her version of events. If she shows up, then we'd hear from her and take that into consideration. If she doesn't show up and the service was proper, then you would get what you're asking for. In general terms, that's kind of how it works. So at this point, any other points to bring up, Ms. Height?
I noticed on the docket listing that there was the admission of the GAL report listed, and I just was curious if Your Honor was going to take any action on that today.
Yeah, it's kind of a unique motion because the guardian ad litem report has been filed, it's been submitted, it's been read by the court. So I'm not sure what more you wanted done with it, Mr. Sills.
I just wasn't sure if you had seen it.
Okay. Yeah, it's there. There's a summary report and then there's the full report. Those are both in the court file, so those are available to the court at any time. So it's as far as the motion to admit the guardian ad litem report,
It's unnecessary.
yeah, it is. It is. Yeah. So I'm gonna deny that particular motion. In that it sounds like you'll be filing a motion for a parenting plan in the future, and as part of that motion, you can make reference to any declarations or information that you have from any other parties, including the guardian ad litem.
Okay, thank you, Your Honor.
Okay. Thank you, Ms. Height. Anything else, Mr. Sills?
That is all.
Okay, great. That'll conclude the hearing. Thank you.
Sure. Just
Yes.
one thing, Your Honor. Would you allow me to bill a few hours to the county? I don't think I need to bill the entire amount. Maybe 8 hours or so of the amount that I did not receive from Ms. Sills.
Yeah, I think what I'm open to that idea. What I would ask you to do is submit a motion, just kind of give me a brief history of where the case has been and
Okay.
what you know about finances and the like. That would be helpful.
Okay. I will
Okay.
do that. Thank you, Your Honor.
Thanks. All right, the next matter I have, I'm just going to look on the Zoom participant list for somebody, and he goes by Tony also.
Yes.
So I'll look for some names that are similar to either
I'm here, Your Honor.
Okay, very good. Thanks, Mr. Guajardo. Oops. Mr. Guajardo, I inadvertently muted you when I was trying to move your picture up so I could see it better. So if you could unmute, please.
There we go.
Perfect. Thank you. Sorry for that. Okay.
Thank you.
All right. So we are here. Let me just pull up my notes. This is on a motion brought by Mr. Guajardo for an adequate cause finding to then modify the parenting plan. So it looks like service was appropriate on June 14th. It looks like Ms. Guajardo was served with a petition, a summons, a proposed parenting plan, a motion for adequate cause, and notice for today's hearing. So, and I read the documents that Mr. Guajardo and declarations that he filed in support of his motion. And I also reviewed the current parenting plan that's in effect, the October 2022 order. I reviewed that. And I also reviewed Ms. Guajardo's input regarding her vantage point related to the situation and the temporary plan or agreement between the parties for Mr. Guajardo and it looks like Ms. Guajardo's mother to share and care for the children for the school year. So that's kind of where I'm at. I've reviewed everything that the parties have filed. And so at this point, I think I'm ready to hear each of you, your argument related to your respective positions on the motion. So any questions before we get going?
No.
Okay. Ms. Guajardo?
I don't have any questions, Your Honor, at this time.
Okay, great. All right, so I'll first hear from Mr. Guajardo and then I'll hear from Ms. Guajardo. Go ahead, sir.
Okay, so a lot of things have changed since the original parenting plan that we've had. I'd get the children every other weekend, holidays. We'd normally split Christmas time. And I'd get them vacations and family functions. I have a new job now that my days off are rotating, which throws a curveball in when I'd have the kids like on every other weekend. But at the same time, Miss Guajardo last October called me up in the middle of the night saying that she no longer wanted the kids. Now, when I say kids, we have a biological son together, Donnie. And when I met Michelle before we got married, she had a son named Bradley, who was 1 year old, and Wyatt, who was also special needs. Now, I never legally adopted those two, but I am the standing father and the only father that they know. And I've showed no prejudice against them, and I am their dad. And that's how it is. And so, last September, Michelle calls me in the middle of the night, expressing to me that she no longer wants the kids, that she can't handle things, that she is emotionally broke down, and for me to come get them. And the next day, her mother shows up at my house with the kids, for them to live with me. Literally the next day. I was unprepared for it, but it was a blessing in disguise.
You'll have your chance.
Me and Michelle gave the children the option of who they wanted to live with. And
how old's Donnie? Is Donnie 7?
Donnie's 9 now.
Okay.
He was 8 at the time when he made the decision, along with Wyatt, who's 15, who's special needs. He's like, I want to live with you, Dad. The kids had many altercations with their mom, argumentative, some being teenagers, with Wyatt, but also in the past, it had gotten physical with Michelle, with the children, to where they had visible marks. They didn't approve of her boyfriend that she has off and on. And it just wasn't a happy environment, to where there was constantly yelling, screaming, verbal abuse from their mom. So I took in Donnie and Wyatt for this school year. Michelle agreed to let me have the kids. We had a verbal agreement that she would seek some help, because she was having a mental breakdown with the kids and things were too much for her. When I received the kids, Donnie was in second grade. I'm sorry. He is below average with his academics. I enrolled them in school with the help of her mom, and Donnie is above average now with the academics.
Can I ask you a question about that?
Yes, sir.
Mr. Wahardo, when I reviewed the case, did you write that down in any of your declarations?
No, I wanted to plead it with you in person, Your Honor. I didn't know how to write everything down, to be honest with you. I'm not a great writer, but I wanted to plead my case with you. I do have the schoolwork, of his academics from previous to now. And like I said, it's not just Donnie. I know I have no legal right with Bradley and Wyatt, technically. I love them as my own. And after me and Michelle got a divorce, I continued seeing the kids, along with, I have older children that are grown up now, and we are a family.
Let me just make mention of this in kind of a follow-up to my question to you. So,
yes, sir.
So the kind of the due process requirements, the things that I'm thinking about under due process, is that everybody has an opportunity to be heard, and also everybody has notice of what the other person's going to be saying. So when we come to this hearing today, what I've read is all the declarations and paperwork that both sides have submitted, and now you're sharing information that's outside the scope of those declarations and what the paperwork has said. So to me, this is new information, and also it's new information to the other litigant, Ms. Wahardo. And so it puts us kind of in a tough position, in that the information that you're sharing, this is the first time that she's hearing it in a formal manner, and she hasn't had an opportunity to review it in preparation for today. So it's problematic. And so I just want you to know that that's a concern and a due process issue that I have to address. So,
Okay. Well, Your Honor, I was informed last time that we talked 3 weeks ago that Michelle was going to serve me with some papers. I've never received the papers.
so meaning her information and her response?
Yes.
All right. Did you serve a copy of those documents to him?
So I did it all online through a processing service, and I had all of those documents submitted to be served to Mr. Wajardo. And I actually spoke with Mary Graybell at the Clatsop County Sheriff's Office, who is in charge of that serving service. And she said that they've attempted to serve him on numerous occasions and he seems to be avoiding them. So, I mean, I've done everything I can to file the necessary paperwork and pay for it all myself.
Okay. Well, I'm glad I raised the issue, because where we stand right now is that Mr. Wajardo hasn't received the information that Ms. Wajardo has submitted and that I've reviewed, and so he's at a disadvantage. And Mr. Wajardo is sharing some information here that's not included in any declarations, and so Ms. Wajardo is at a disadvantage. So the way that we can even the playing field is make sure that all parties have the documents of the other parties and know what they're saying. And if there's new information, then related to schooling and school performance and other issues that weren't included in original documents, that would need to be submitted in additional declarations. So let me just back up then a little bit on as far as service. I'll make mention of this. The law tends to be very formal, and doesn't necessarily keep up with the times. It's more reactive than proactive. So in the past, service has always been done through either personal service, here are some documents you're served, or through the U.S. mail, or through publication in a newspaper. And so those are kind of the base requirements. If parties agree to service via email, in today's world, I mean, who functions without email? Most everybody uses email. And so if parties agree to receive documents from the other party via email, the parties are free to do that. And then that saves everybody a little bit of time and cost and effort from either mailing or sending them documents in the mail or serving them personally. So I'll just ask the parties if you're interested in serving each other with documents via email. Maybe I could start with Ms. Wajardo. You're the petitioning party, and then from Mr. Wajardo.
If he doesn't have a problem with it, I have no problem doing that via email.
Okay, Mr. Wajardo.
I have no problem either, Your Honor. I haven't been trying to avoid the sheriffs or anybody, but since when I'm home, I was home all last week. I'd been on vacation, and I'd planned on having a family vacation with the children, but Michelle wouldn't relinquish them to me. But I was home all week from the 4th of July, or actually the 1st of July to the 13th of July. I was home. So,
so you're okay with service via email?
Absolutely, Your Honor.
And Ms. Wajardo, you're comfortable with that also? Do you have each other's respective emails?
No.
Okay.
Sorry, I have the email that he provided on the documents that were served to me, the tonyisage.com. If that's...
Is that still a good, valid email address that you'd like to use, Mr. Wajardo?
Yes, Your Honor.
And could you repeat it again? What was it?
tonyisage@gmail.com.
Okay. All right. And then, Ms. Wajardo, do you have an email address that he could use?
Yeah, it's Michelle Wajardo.
Okay. I'll give each party a moment just to note those down. Yes, sir.
Let me write this down real quick.
Please.
I'd just like to say, Your Honor, every single thing that he has brought up, I have no problem discussing and I can share my point of view. There is a very big difference between his perception of events and the factual stuff that actually happened. And like all the documents that I provided, like as my exhibits, that were, brought in whatever, like kind of goes over all of that. And then as far as 4th of July, it wasn't his scheduled weekend. So like
It
4th
wasn't a
of July
weekend.
was on a Thursday, and so that was my day. So it wasn't anything malicious.
Okay, so just so each of you are aware, I'm not going to make any decisions related to July 4th or anything that's pending with these motions, because what I said before still applies, is that both of you need to supply each other with additional information so you both know what the other is saying, so then you can reply to it. So with the agreement with service through email, the parties will be free to serve each other the documents that you file with the court. What we'll need to do is set a date, so you all know kind of what the date is that you can work towards to make sure those documents are filed and then shared with each other. And then, so let's do that now. Let's take a look at a date and the time. So we could look generally a 2-week time frame is generally in order, because what would happen is that Ms. Guajardo, you'd need to serve those documents to Mr. Guajardo via email. He would get them, and then he would have an opportunity to respond to those. And then when Mr. Guajardo responds, and if he supplies additional information such as school performance and the like, you would get all that information, and then you would be able to submit a reply declaration or reply information to what he's saying. And so you'd file that and send him a copy of your information. So 2 weeks generally allows us enough time to get all that done. So if we look at the calendar, today's the 17th, so we'd be looking at the 31st of July at 9 a.m. So I'll just ask the parties how your schedules look on that day. So Ms. Guajardo, you're the petitioner. How does that look?
That's fine with me. I'm sorry, you said July 31st?
July 31st, it's a Wednesday at 9 a.m. And Mr. Guajardo, how does that look for your schedule?
That's fine too, Your Honor.
Okay. All right. So at this point, we'll move this hearing to July 31st. Ms. Guajardo, you're going to make sure that all the documents that you filed with the court, you'll send those and serve those upon Mr. Guajardo. You still, each of you, even though you're serving via email, you still need to fill out what's called a declaration or proof of service, meaning you'd have a party say, on such and such a date, I emailed these documents to the other party, and list all the documents that you sent to them. And then that has to be filed with the court.
Your Honor, I have a question for you. So with my information of the school, the academics of Donnie and Wyatt, even though Wyatt is not biologically mine and legally, I guess I have no right to him, even though I am his acting father and his only father, along with Bradley. Can I include his academics also in with this, or is it just solely Donnie, since I'm legally for Donnie? Because I'm looking out for all the boys.
It's the latter. This action applies only to Donnie.
To Donnie, okay.
Yeah.
Okay.
You had a question, Ms. Guajardo?
Not necessarily a question, but I just wanted to address the reason that Donnie was behind in his academics was because of COVID.
So it's kind of beyond the scope, because that you'll be talking about that information in your declarations.
I just wanted to make sure, like, it was planned out with his school counselor and everything. I didn't just keep him behind for no reason. So thank you.
All right. So any questions as we move forward and prepare for the next hearing on the 31st?
Yes, Your Honor. So for me to add this more information, do I need to go to the courthouse then and file it? Or what's the proper things that I need to do, please?
Yeah, so with any declaration or information that you want to share, you'd write it up and sign it under the penalty of perjury. And that document or documents and any exhibits that you want to attach to them, we would file that with the court. So that's done physically with a paper copy that you give to the clerk. That's scanned into my system through the clerk's office, so I have access to it. And then you would send a copy of that all the documents that you provided to the court. You'd send those to Ms. Guajardo, and then thereafter, after you've sent it, then you'd submit a declaration of service saying on such and such a date, these documents were sent via email to Ms. Guajardo, and then that's filed with the court, the declaration of service.
Okay. Okay, thank you, Your Honor.
Okay. And then Ms. Guajardo, any final questions?
Not at this time, Your Honor.
Okay. All right. So we'll see everybody on July 31st, Wednesday, 9 o'clock, and we'll make some decisions on the motion.
All right, thank you.
All right. Thanks.
Bye.
Sorry, just a moment. So when we come back on July 31st, would I be coming back to this courtroom? Like, it will be in the same place?
Generally, it's in this courtroom. It could be in a different courtroom, so you'd have to look at the schedule for that particular day. You also have the option of appearing via Zoom, and Mr. Guajardo has the option of appearing in person or via Zoom. So all parties can, whatever means is easiest for you. Okay. All right, thanks.
Thank you, Your Honor.
All right, that'll conclude the hearing. That also concludes the matters that were docketed on the docket this morning. So does any party, were you anticipating your case to be called, but it wasn't called? Okay, hearing none, that will conclude our hearing, the docket for today. I'll go ahead and.
I've got a question.
Oh, go ahead.
So I thought that Mr. Utter and I had a case today.
And what's your name, please?
My first name is Kirby and last name Young.
Okay. And do you by chance know the cause number of your matter?
I don't. I'm sorry.
Okay. That's okay. We can look it up. Okay, the clerk did a quick search and she indicated that the case is noted for July 24th at 9 a.m.
July 24th. Okay, perfect. Thank you.
You're welcome.
Bye.
Okay, with that, I'll go ahead and end the Zoom call.